Hello, my name's Steve, and I'm an expert on the European communities. A number of people have been saying online that signing the Treaty of Rome was illegal, so I thought I'd quickly go through the constitutional position and then go through the history. If you're looking for someone to say that a referendum was needed, you will not find it in Blackstone. Treaties are signed using the royal prerogative, and Blackstone was very clear on this. He said it's in one person's hand to make it strong and powerful and quick, and if this was in the hands of the committee, it would weaken us as a country. Dicey would refer to Blackstone saying it sounded really great, but it's just not how it works. Dicey would argue that it's in the hands of the cabinet, and the cabinet is in fact a committee. The only things you'll find about a referendum in Dicey are the reasons why it should never be in our constitution. And with Blackstone and Dicey out of the way, it all falls to one man, Raymond Blackburn. Raymond Blackburn argued that this was a treaty like no other treaty, that the government didn't have the power to sign it, and consequently he took them to court. He lost the first case and then took it to the Court of Appeal. Her Majesty's judges, as the guardians of the British Constitution, should be asked to declare the constitutional position in relation to the government's application to sign the Treaty of Rome and join the common market, and that the treaty's provisions can be validly accepted only if a new constitution is adopted with the consent of the British people, Mr. Raymond Blackburn of Chiswick told the court. And he lost. Mr. Blackburn was quite right, so far as his lordship could judge, in saying that if this country should go into the common market, the significance of the treaty would commit at least the executive irreversibly to the joinder of the market, and further, that in some degree the sovereignty of these islands would be shared with others. The court ruling was that there was a separation of powers, and the Queen was just exercising hers. Lord Coleridge, Chief Justice, was quoted in Ruston-G versus the Queen, 1876. She acted throughout the making of the treaty and in relation to each and every of its stipulations in her sovereign character, and by her own inherent authority, and as in making the treaty and performing the treaty she is beyond the control of municipal law, and her acts are not to be examined in her own courts. Now take a close look at this article. That exact same article was cut and glued and stapled onto a piece of paper and included in FCO 301048. Do you see it? And that was attached to a report from Sir Vincent Evans, one of the legal advisors, explaining how the courts had concluded it was legal to sign the Treaty of Rome, including some of the points that Blackburn made, which were the supremacy of law, automatic binding of law, and how our courts have got to follow the decisions of the European Court. But you won't find anything about the Bill of Rights, because that will be in FCO 301520, the 1972 archive. Because in 1972, Alan Ross McWhirter, one of the twins that wrote the Guinness Book of Records, took the government to court again. He accepted the Blackburn decision, but since the treaty had been signed, he said this had changed things, that the government were now in violation of the Bill of Rights. Like Blackburn, he lost, and he took it to the appeal court, and he lost again. The court was quick to point out that the Bill of Rights conferred on the Crown and maintained in them all the honours, styles, titles, regalities, prerogatives, powers, jurisdictions, and authorities to the same belonging and appertaining, and that those powers were conferred on William and Mary on the abdication of James II. So when the clauses of the Bill of Rights are read together, their effect was that there was in the Crown, as fully as ever it was, the prerogative of treaty-making power, which had succeeded from one generation to another down to today, and was certainly in the Queen through the executive government. There was nothing in the succeeding words on which Mr. McWhirter relied to limit it, so that even though the treaty had now been signed, the courts had no regard to the terms of treaties. They also referred to Attorney General for Canada versus Attorney General of Ontario. The stipulations of a treaty duly ratified do not within the Empire, by virtue of the treaty alone, have the force of law. But that isn't the end of the legal action. Mr. Louis Bradford took out a writ under the Act of Settlement 1701. He believed he had a lot of support, and he was going to take it all the way to the House of Lords. That was kicked out of court so hard, it hasn't landed yet. But that's not the end of the story, as William Rees-Mogg, the father of Jacob Rees-Mogg, brought together a legal team including David Pannick to fight the signing of the Maastricht Treaty. And there we learn that Blackburn versus Attorney General had been confirmed by the House of Lords in 1990. To try and bypass Blackburn, Pannick quoted from a number of old authorities, including the case of the King's prerogative in Saltpetre 1606 from Coke's reports. I think it's fair to say he threw everything at it. including Raymond Crotty versus Anne Taoiseach, 1987. Apparently, if you run out of British case law, you can just quote Irish case law. The government's case largely relied on Blackburn versus the Attorney General. Bannock's argument did kind of work, and he convinced the court that there may be exceptions. But ultimately, the court rejected the argument on the basis that either Blackburn did apply or the case failed on its own merits. But that wasn't the only case. Rodney Atkinson, the brother of Rowan Atkinson, got together with Norris McWhirter, the brother of Alan Ross McWhirter, and they laid misprision of treason charges in the most embarrassing case to date. That one was kicked out of court so hard, they haven't stopped laughing about it yet. Now, Rodney might say he got the last laugh because the United Kingdom left the European Union. But after the vote, the question was raised, does the government have to ask Parliament to leave? And that meant that David Pannick, who is now Lord Pannick, goes to work for Gina Miller. To argue the government need Parliament's permission, he cites the Bill of Rights. But the Supreme Court knocks that argument down, citing McWhirter versus Attorney General. The clauses, they said, must be read together. And when the dust settled, there were just two constitutional precedents. Blackburn versus Attorney General, and Coke and the case of proclamations. It was the big rematch. And it went the full 15 rounds. But at the end, it was Coke victorious, in a split decision. Okay, so maybe there were some other constitutional principles, but those two were the main ones. So yes, it was legal to sign the Treaty of Rome. You didn't need a referendum. The government could sign sovereignty away, and it was consistent with the Bill of Rights. They've been upheld by our highest courts, and now form the basis of our constitutional principles. Although I'm sure there are some armchair experts who think otherwise. That's the end of the film, and thanks for watching.